to Legal Guide Philippines, where we simplify the law to help you make better choices. I'm Attorney Ramon Ramirez, and I'm with my partner,
Attorney Erwin Zagala. So today, Attorney Ramon, we're talking about something super exciting. And that is quitclaims and waivers.
Super exciting.
Yes. well, it is exciting when it does happen. Kasi parang hindi naman normal course of everyday nangyayari. Di ba? Unless you're in HR, talaga ikaw nagpo-process ng mga umaalis na empleyado. But for most people, parang once every quarter or year yan. Kasi hindi naman ganun tuloy-tuloy yung paglabas ng mga empleyado.
Right.
But it is exciting when it does happen. And let's take into context yung naging tanong uli nung natin.
Si Nat.
Episode, si Nat.
Okay.
So,
Ano sabi
i-break
niya?
down natin yung tanong para lang mas naintindihan.
Okay.
So, si Nat, I think umalis or pinalis. Okay? And sa kanya, tinapos naman niya yung clearance niya. Binigay na yung company property.
Okay.
Nagpirma pa ng non-compete and non-disclosure agreement.
Okay, may NDA
Kaya
pa.
lang, pinag-uusapan na is final pay. And sinabi daw ng HR niya, pag hindi ka pumirma ng final pay,
Quitclaim.
ng quitclaim, wala kang final pay.
Oh.
So essentially, pirma for pera. Okay, so
Quitclaim for pera.
yes.
Yan.
Okay, so ang tanong niya basically, wait, illegal ba to? Required ba talaga to? Ano ba yung magiging effect nito? So para sagutin yan, we will build the foundations.
Okay, wow. Foundations.
Module by module. Papaliwanag natin yan until at the end, pwede mo na sagutin on your own kasi naiintindihan mo na how this goes.
Exciting.
So first thing we talk about is, ano ba talaga yung quitclaim and waivers? Okay, so let's define things. Ang quitclaim, you're quitting a claim. So the definition is to release or relinquish a legal claim to.
Okay.
Basically, ayoko na, hindi ko na hahabulin itong bagay na to.
Pwede kong habulin sana, pero ayoko na.
Yes,
Yan,
kasi nire-release or relinquish ko na. So, yun ang quitclaim.
Okay.
Now, yung waiver naman, ano ba ang pinag-uusapan dito? Waiver is the act of intentionally relinquishing or abandoning a known right, claim, or privilege. So, ano pinagkaiba ng dalawa?
Similar.
Actually, halos wala. Kasi, tama yung sinabi mo, Attorney Ramon, you are entitled to something or you may be entitled to something, pero binibitawan mo na. Hindi ko nahahabulin yan.
Yun.
Okay.
Yun.
So,
Pareho yan, sir. Can we use it interchangeably, more or less?
Oo.
Conceptually, no?
Oo, kaya kung makikita mo sa ibang mga dokumento, ang phrasing niyan, waiver and quitclaim.
Yun.
Pero actually, ang tama pala, waiver or quitclaim. Kasi pareho lang legally yung effect nun.
Yeah.
Diba? Now, ilagay natin sa konteksto ng labor law.
Okay,
So,
labor law.
When an employee signs a quitclaim or waiver at the time of resignation in favor of his employer, basically, nire-renounce na or nire-relinquish. Sa Tagalog po, binibitawan ng empleyado yung legal claim niya against the employer.
Okay.
Ayan.
Meron ba dapat?
Sasagutin natin later yan.
Okay.
Pero pinag-uusapan lang muna natin ano ba yung function nito sa batas. Okay? So, ang quitclaim po is executed in order to settle once and for all the disputes arising from such employment and to foreclose an impending litigation. So, on its face, ito na ha, binibigay ko na sa'yo lahat ng entitlement mo.
Okay.
So, quits na tayo. Pag pinirmahan mo to, ibig sabihin, nakuha mo na lahat ng kailangan mo. Ako naman, wala na akong utang sa'yo. So, yun ang translation ng quitclaim.
Para siguro, attorney, di ba, parang, kasi once nagbigayan na ng kuwari, binigyan na ni employer lahat ng entitlements, no? Nung nag-resign or umalis na empleyado, para maiwasan siguro na may hahabulin pa na unforeseen. Ito na nga, binigay na namin. Ganun ba yun, attorney?
Binibigyan na ng closure.
Oo.
Tapusin na natin
Tapusin na natin to. Ito na lahat ng nasa sa'yo. Pag pinirmahan mo to, sinasabi mo na, wala ka nang habol pa ha, kasi binigay ko na lahat sa'yo. Parang ganun ang intention.
Exactly. And it makes sense naman on the part of the employer. Kasi, naglabas na ako ng mga kailangan mo. Ano pa ba hihingiin mo? Di ba? Binalik mo naman yung mga gamit. Ako naman, final pay mo, yung mga hindi mo na gamit na leave, nilabas ko na.
Yeah.
So,
posible kasi na baka mamaya mag-isip pa si employee na paano ko pa kaya paano pa ako makakahingi ng additional? Posible ganun, ano?
So, ito na yung usapan natin. Para, in a sense, para siyang resibo. Oo, na parang, ito, tapos na tayo. But, itong resibo, actually, mas may legal effects kasi sinasabi mo, there's a relinquishment or pagbibitaw.
Okay.
Resibo kasi, natanggap ko lang. Diba? So, ito, may dagdag. kumbaga, upgraded resibo to, in a sense. Okay, so the next question is, ang lakas pala ng ibig sabihin ng quitclaim and waiver, no? So, attorney, pwede nga ba sa batas yan? Saan po sa batas makikita yung pagpapahintulot or authorization for people to do that?
Saan nga yun?
Ang sagot, pwede ba to sa batas? Yes! At ang sagot po ay nasa civil code. Kasi under the civil code, pinag-uusapan po yung waiver of right or privileges.
Yan.
In fact, nandun pa siya sa start ng civil code. Nasa first few articles, it's in Article 6. Attorney Basa, baka naman pwede pagbigyan tayo ng isang Article 6 dyan.
Article 6, rights may be waived unless the waiver is contrary to law, public order, public policy, morals, or good customs, or prejudicial to a third person with the right recognized by law.
Yan. So, pwede.
Yes.
You can waive your rights. Malinaw na malinaw po sa civil code. And in addition to this, Attorney Ramon, actually, hindi lang yung pag-waive. Pwede ka pang magsaksak ng stipulations. Now, ano yung ibig sabihin ng stipulations? Yun yung mga provisions or mga bagay-bagay na nilalagay sa kontrata na dapat sundin ng bawat partido. And this is found in Article 1306 naman.
Okay, 1306. 1306, babasahin ba natin yan, Attorney?
Yes.
Okay.
Sige.
Article 1306. The contracting parties may establish such stipulations, clauses, terms, and conditions as they may deem convenient, provided they are not contrary to law, morals, good customs, public order, or public policy.
Yan. So, ang ibig sabihin po ng sinabi ng batas dyan is pwede kang maglagay ng mga stipulations, clauses, terms, and conditions as long as wala silang sinasalungat na batas, morals, good customs, public order, or public policy.
Yun. Nice.
So,
So sa waiver yan, Attorney Erwin.
Yes.
Pwedeng ilagay
And
yan.
in contracts in general,
Okay.
pwedeng mangyari yun. Kasi essentially, yung waiver po or quitclaim, wala siyang pinagkaiba sa normal na kontrata.
Tama.
It's a contract. So, yung rules po ng contracts, nag-a-apply din po sa waiver and quitclaim. Now, ang tanong, in practice, Attorney Ramon, ito po ba is nirecognize na ng Supreme Court sa mga kaso na dinicide? And the answer is yes. In Pilipinas Shell Foundation Incorporated versus Fredeluces.
Fredeluces.
Yeah, it's a 2016 case. Sinabi po ng Supreme Court, contracts in the nature of quitclaims are contracts in the nature of a compromise where parties make concessions, a lawful device to avoid litigation. So, recognized po even ng Supreme Court.
Nice.
Okay? And nabanggit dito sa kasong to, compromise daw siya. Quitclaims are contracts in the nature of a compromise. So, ano naman ang ibig sabihin ng compromise?
Ano nga, Attorney?
Attorney Basa, parang magandang balikan ng civil code. Pagdating
Civil
sa
code na naman
definition,
tayo. Madami tayong civil code today, ha?
definition ng compromise.
And this is in Article 2028.
or 2020.
2028. A compromise is a contract whereby the parties, by reciprocal concessions, avoid a litigation or put an end to one already commenced. Yan.
Yan. So ano yung keywords dito ha? It's a contract.
Okay.
Malinaw na malinaw. Whereby, by making reciprocal concessions, ibig sabihin, ako may binigay, na sige, pagbibigyan na kita dito sa puntong to. Ikaw naman, magbibigay ka rin. Yun ang
Okay.
ibig sabihin ng reciprocal concessions.
Okay. Nagbibigayan sila.
Nagbibigayan sila.
Okay.
Dahil doon, nakapag-avoid po ng litigation. Sa madaling salita, hindi na po sila nagkasuhan. Or kung sakaling ongoing na po yung kaso, pwede pong ihinto yung ongoing na kaso. So, hindi po balakid na may kaso na. Di ba? Yun, Attorney Ramon, ng parang misconception ng ibang tao na parang, hindi, pag nagkaso na, wala na tayong magagawa. No po. At any point in the case, actually, pwede po tayo na mag-compromise with each other. That way po, yung kaso, mahihinto po. Okay? So, wag po tayo maniwala na pag may kaso, tuloy-tuloy na po yun. I've had cases na actually nasa gitna na, labor to. Nakapagpasa na ng mga position paper. And then, nakapag-usap bigla yung complainant and yung, respondent, yung kumpanya. And then, biglang nag-usap. Yung pala, hindi lang nagkaintindihan. So, kahit nakapagpasa na ng position paper, by the way, by the time na umabot ka ng position paper, medyo malayo na yun. Ang layo na ng tinakbo ng kaso noon. Tapos na kayo ng mediate, ng SENA, ng mediation, ng mandatory conference, position paper na. hinahayaan pa rin po na mag-compromise, assuming na nakapag-usap naman po ng maayos. Which brings me to the next point. After this break, pag-uusapan naman natin, kung magpapa-quit claim or waiver ka, ano yung mga dapat na gawin?
Yan, importante yan.
Yan. So, welcome back. And now, pag-uusapan natin, what are the requirements for a valid quit claim or waiver? Attorney Ramon, kung kunwari ikaw employer, pwede bang ibabato mo lang yung papel? O sige, pirma mo yan.
Sana pwede. Sana pwede.
Ikaw pa yung mataray. Pirma mo yan. No. Ngayon, the law recognizes that quit claims can actually be a tool for oppression or used to abuse. Na parang hold up ang dating, di ba? Na hindi ko gagawin to hanggat hindi mo...
Quit claim ka muna. Okay. Tama ba yun?
So, ang sinabi ng Supreme Court sa kaso po ni Plastimer Industrial Corporation versus GoPo.
Okay.
Ito, 2011 case. Bagong-bagong kaso.
Bagong-bago. Oo.
A quit claim is a valid and binding agreement between the parties. Provided, ito na, Attorney Ramon.
Provided what?
Importanteng word dito. Provided that it constitutes a credible and reasonable settlement, and the one accomplishing it has done so voluntarily and with a full understanding of its import. Anong magic words dyan? Provided. So valid yung quit claim. Kung reasonable naman yung settlement and yung pumipirma po voluntaryo yung pagpirma niya, hindi siya pinilit, hindi siya nilinlang, hindi siya niloko. And naiintindihan po niya kung ano yung pinipirmahan niya. So if those elements are there, then okay tayo sa quit
valid siya. Okay.
So let me summarize naman,
Okay.
So kung sakaling may tinitignan akong quit claim, so kunwari may kliyente or estudyante na lumapit sa atin and, attorney, pa-check mo nga, tama po ba itong ginawa ko? Or kunwari may reader, di ba? Attorney, pinapirma po ako ng quit claim. Tama po ba yun?
Marami yan.
Tama po ba yun? Okay. So as a lawyer, ako, 3 po ang titignan ko.
Ano yun?
And itong 3 to, actually, galing din sa Supreme Court cases. This came from F.F. Cruz and Company versus Galandes. Mas bago tong kasong to. 2019 naman. 2019 case. So, may 3 po na tinitignan. First off, tinitignan is, there was no fraud or deceit on the part of any party.
Okay.
So both kasi pwedeng manloko rin yung empleyado. Pwede rin manloko yung employer. So on both sides, walang panloloko. So kung kunwari yung binigay na computation, ito naman yung tama. So tama yung records, walang panloloko. Or ito po talaga yung pinasok ko. So pwede yun. Second is, that the consideration for the quit claim is credible and reasonable. So kung sakaling may ibibigay, tama naman yung computation or reasonable naman yung pinagbasihan. Kaya hindi ang pinakaayaw namin is kung sakaling may quit claim yung hinugot sa hangin. Ito yung feeling ko yun yung ilalagay na value sa...
hindi okay yun. Dapat merong pinanggagalingan.
And now the third principle is that the contract is not contrary to law, public order, public policy, morals, or good customs, or prejudicial to a third person with a right recognized by law.
Very important, Attorney Erwin.
So yun ang tinitignan ko kapag tinanong ako, pwede ba yun? Tama ba yun yung ginawa? Ayan. So ibabalansi ko yan using those 3 elements there found in the case.
Yan.
Now, ang tanong, Attorney Ramon, kung sakaling may quit claim na naganap, kanino po bang trabaho na i-prove na tama yung quit claim? Na dumaan naman yung 3 elements na yun nandun. Sa tingin mo, sa employer or sa employee?
Tingin ko sa employer.
Sa employer. Kasi in terms of labor laws, usually sa employer po yung burden of proof. Okay, so trabaho po ng employer to be able to show that there was a credible and reasonable settlement of what an employee is entitled to recover. And more importantly, yung pumirma po, yung empleyado has done so voluntarily and with full understanding of its import. Again, ang dagdag po na kaso na nagsusupport dito is C versus Meat Incorporated. It's a 2017 case naman. So, Attorney Ramon, ang conclusion sa dami ng mga sinite natin ng mga kaso, recognizing the fact na valid yung quit claim and waiver, ang conclusion natin is not all waivers and quitclaims are invalid as against public policy. Pwede po.
Yep.
The only time na magkakaproblema po tayo is when there is clear proof that the waiver was
What?
wrangled from an unsuspecting or gullible person. Basically, inutu-utu po yung empleyado.
Niloko.
Pumirma ka na dyan. Or the terms of the settlement are unconscionable on its face. It is this time that the law will step in to annul the questionable transaction.
Ano ba yung unconscionable on its face, Attorney Irwin?
Kunwari, entitled siya sa 10,000 pesos. O sige, quit claim na natin. 1.5 na lang. Okay na yan. Di ba?
Pero parang ano talaga, parang napakadaya.
Madaya. And then walang basihan.
Diba?
So when it is shown that the person making the waiver did so voluntarily with full understanding of what he was doing, the consideration for the quitclaim is credible and reasonable, and the transaction must be recognized as valid and binding.
Yeah.
So this is from another case, Samaniego versus NLRC. It's a 1991 case, and it's quoting Periquet versus NLRC 1990 case. Medyo matagal na. So, ang conclusion ng mga kasong to, basta mapatunayan mo na maayos naman yung terms and naiintindihan ng taong pumipirma, wala ka magiging issue doon.
Nice.
Now, some tips on how to show na naiintindihan. Kung ang empleyado mo hindi naman marunong mag-English, baka magandang may Tagalog version ka. Or Filipino version.
Okay, that's a good tip. Oo.
Or maganda rin kung sakali recorded habang pinapaliwanag mo. So line by line, maganda ipaliwanag mo. And magandang tanongin mo harap-harapan, pumapayag po ba kayo sa terms na nakikita ninyo rito? Yan. So those are some tips for employers on how to do a quitclaim or waiver ng maayos. Now let's talk about estopel.
Ano yung estopel, Attorney?
Yan. So ang estopel, it's a doctrine under the law, and it has some applications when it comes to quitclaims or waivers. Okay? So, ganito kasi. Ang ibig sabihin ng estopel, easiest way to explain it sa non-lawyers, touch move.
Okay.
Pag ginawa mo na to, wala nang babuyan. Yan na yun, tuloy-tuloy tayo hanggang dulo.
Okay.
So kung sakali, pag pumirma ka ba ng quitclaim, touch move na ba yun? Hindi mo na pwedeng bawiin. Or ay naku, yun na talaga yun. Well, ito naman ang sinasabi ng Supreme Court. As a rule, deeds of release and quitclaims cannot bar employees from demanding benefits to which they are legally entitled to from from contesting the legality of their dismissal. The acceptance of those benefits would not amount to estopel. So hindi touch move according to Philippine Carpet Manufacturing Corporation versus Tagyamon. It's a 2013 case.
So ibig sabihin pag nag-sign si employee ng quitclaim, hindi automatic na hindi na niya pwedeng i-claim yung mga what he is still legally entitled to. Tama ba?
So the magic word there is kung may kulang pa.
Okay.
So ito under prevailing jurisprudence, ibig sabihin sa mga kaso na promulgate recently, the fact that an employee has signed a satisfaction receipt for his claims does not necessarily result in the waiver.
Okay.
The law does not consider as valid any agreement wherein a worker agrees to receive less compensation than what he is entitled to recover.
Okay.
So yung mga quitclaim and complete releases executed by employees do not stop them from pursuing their claims arising from unfair labor practices. The basic reason is this: quitclaims and or releases are against public policy and therefore null and void.
Nice.
Kung sakaling may kulang pa. Again, another case to support this is Lourdes Marcos versus NLRC. That's a 1995 case.
Dami mong kaso
Oo, kasi kailangan natin ipakita talaga that the Supreme Court supports this position. Okay. So, ito na, Attorney Ramon. I think ang dami na nating binigay ng mga foundations. Ready na tayo na sagutin yung mga tanong.
Okay.
Yan, okay. So, first question. Di ba sinabi ni Nat kanina, required po ba ng batas na may quitclaim? Actually, no. It's not a requirement under the labor code or the law for that matter. Ang quitclaim po and waivers, it became a best practice. So parang nakita ng isang kumpanya, okay itong ginagawa ng kumpanya to. Kinopya. And then maya-maya, parang sobrang dami na nang gumagawa. Parang akala ng mga tao, parang requirement to. Well, actually, it is not. kahit na umalis yung empleyado without a quitclaim, wala naman pong legal effect na masama kung sakaling wala. Kasi dagdag lang po yun. It's a best practice. Would I recommend it? Yes, libre naman po na gumawa ng quitclaim. However, okay, quitclaim, ito po kasi, it's an opportunity to be able to clarify with the employee. Kaya ako naman siya gusto. It's a conversation starter.
Tama.
Na ito yung entitled ka. O after nito, binigay ko na lahat ng nararapat sa'yo, wala na tayong habulan. Ha? So it's an opportunity to have that conversation. Okay? And for me, kung sakali wala ka naman tinatago sa empleyado, you're transparent in the negotiations, pinaliwanag mo isa-isa, o bakit ito yung computation? Wala kang tinago na dapat entitled siya na inipit mo. Hindi ka dapat matakot na mag-quitclaim.
Agreed.
Tuloy mo lang dapat yan. Okay? Kailan ka dapat magdalawang isip na mag-quitclaim? Kapag medyo may tinatago ka, or iniipit mo, or niloloko mo.
Wag ganun.
Kasi kung
That's
yun
bad.
ang intention mo, sabi nga ng ibang kaso sa Supreme Court, kahit na mag-quitclaim yan, it does not bar or stop the employee from going after you. So, going back to everything we've said, if maayos naman yung computation mo, credible, reasonable yung settlement mo, wala kang tinatago, pinaliwanag mo ng maayos and naiintindihan ng empleyado, go for it. If may tinatago ka, may iniipit ka, no amount of quitclaims would be able to save you. Kahit na 3 pa yung ipapirma mong quitclaim waiver, pwede pa rin yan pumunta sa
Ang dami, 3.
Hindi kasi raw, yung isa kukunin ng notaryo, yung isa sa company, yung isa sa empleyado. Pero kahit gawin mo pang 6 yan eh. Kung balak mo manloko, it won't work.
That's true.
Because the employee can always ask for help from Dole. And so I hope that was able to help our viewers and readers. We discussed a lot, and I hope we were able to drive home the point. For most of you, this video was more than enough, and if it makes your life easier, then you're welcome. But there are those of you who will watch this video and end up asking more questions such as, Attorney, paano ba mag-terminate ng empleyado? And Attorney, ano ba yung clearance process for terminated employees? If that's you, then I invite you to check out the Complete Employee Discipline System, where we teach you a roadmap in handling employee cases from start to finish. Get the book now at info.legalguide.ph/discipline today. Now, one last thing. No amount of paperwork can cover up the fact if dinadaya mo ang empleyado mo. Even if they sign a waiver, they can still claim that in Dole. So, from the beginning, try to comply with everything para from start to finish, wala kang pumirma. So, was it that simple?
Now go make better choices.